Hey everybody, good to see you tonight. I thought we would try the video with me actually being on screen again rather than just my voice over the PowerPoint to kind of keep switching it up a little bit and keep things fresh. Now, as far as this video goes, I have a firm base beneath me, so I can't promise any falls today. So if that's what you tuned in for, maybe we'll get a little more content in tonight. So today what we're looking at is another Supreme Court case. This is going to be the second one that we studied in our unit. The first one, lest you forget, is Marbury versus Madison. Now, Marbury versus Madison was a really important one to review if you want to actually go back and maybe look at that before you get really into this video, because Marbury-Madison was a Supreme Court case where the judicial branch really got its legitimacy as a part of the United States government. And it was out of that case that the Chief Justice John Marshall created the idea of judicial review. Judicial review was that idea that it was the Supreme Court and the judicial branch that gets to determine if laws are constitutional or not. So that really made it a legitimate force within the government. Now, this case in McCulloch versus Maryland, while a little bit of a different animal to Marbury versus Madison, does kind of play into a role here in that it's going to be the Supreme Court that gets to make the decision on whether what they're talking about is constitutional. So let's get into it. McCulloch versus Maryland, all right? You can see those two names there. But what McCulloch versus Maryland is all about is the bank. All right, the bank. It's always about the bank. And of course, that means hopefully you're thinking Alexander Hamilton, because even though he's gone by now, his legacy is still on display here. All right, so what happened? Well, McCulloch versus Maryland is about what happens to the national bank. The national bank has branches in every single state throughout the early America. So there's a national bank branch in Maryland, there's one in Pennsylvania, even though its headquarters are in Washington, D.C. It's in Maryland, obviously, where the problem happens, with a man named James McCulloch. Now, James McCulloch was the bank manager of the national bank branch in Maryland. So he was running the bank there within the state of Maryland. And what happened was the state of Maryland got very upset. They didn't feel like it was fair that the federal bank in their state was not being taxed while other state banks were. And so they passed a law through their state Congress to tax that national bank branch. Well, McCulloch, when he heard this, refused to pay the tax. And so what we have here is a federal bank refusing to pay a state tax, even though they're within the state territory. And because of its nature of federal versus state proposition, this case naturally goes up to the Supreme Court, and the head of the Supreme Court is John Marshall. Now, I hope you remember Marshall. There's some videos in our student folder if you want to review who Marshall is and what he's all about. But he's that head of Supreme Court. He's a federalist and kind of keeps his federalist tendencies. And Marshall has really two questions to decide. The first one is he has to say to himself, all right, is the bank in fact a constitutional thing? Does it have legitimacy even though it's not in the Constitution? The second question, and the key question then, is if the bank is a legitimate power, well, can a state tax a federal bank, or can the state tax a federal entity at all? And to really understand this, guys, we have to quick review what the powers are in the Constitution. We have to go back and remember, well, what are they and do they exist? So the first one that we have to look at are called expressed powers. All right, and these are powers for the national government. These are powers written into the Constitution. They're black and white. It's clear as day. I could open it up today and say, here are the list of powers the national government has. We call those expressed. They're expressed in the Constitution. Now, the second power then, all right, and this should be review, are reserved. And the name comes from the idea that if those powers are not expressed in the Constitution, they're supposed to be reserved for the states. So these are state powers, and these are things that are going to vary across state lines. Speed limits, drug laws, gun laws, whether or not you can wear a mask in Virginia and things like that. These are the reserved powers. Now, these come from the 10th Amendment. They're not originally in the Constitution, but they're in the amendments. The third one are shared powers. Shared powers are obviously powers that both the national and the state can do. Things like shared court system that can both tax and whatnot. And then the final and the tricky one that really kind of comes out of this is implied. And implied powers, ladies and gentlemen, are not in the Constitution, and that's where the bank comes from. Now, this is really Hamilton's big idea, in that he's saying, well, implied powers, while not in the Constitution, they're implied that the federal government needs them. So if an expressed power is to carry out revenue and collect taxes and facilitate commerce, then it's implied that the national government needs a bank in order to do that. So these are national powers, and they are not in the Constitution, so they drastically increase the power that the federal government has, which is really Hamilton's big idea. But what Marshall has to answer is, are those in fact legitimate? Now, when Hamilton created them, we didn't really have judicial review yet, and so we never had a chance to really go back and say if they were actually constitutional or not. So Marshall looks at this and he says, you know what? I can point to a clause in the Constitution called the Necessary and Proper Clause, and it says in there that the federal government can do anything necessary and proper to carry out its expressed powers. And he agrees with Hamilton. He says, yes, implied powers are in fact a national thing, and therefore he validates those as a real thing, and therefore the bank is validated. But the second question is, okay, well, can the state tax the federal bank? Well, to understand this, we have to look at our last key piece here, and Marshall looks at a little thing called, I think I missed one there, Supremacy Clause. And the Supremacy Clause states that what happens when a national and a state law conflict? It's very clear in the Constitution that the national government is supposed to win. So when it comes to a state trying to tax a federal entity, Marshall realizes that if he allows this to happen, every state could tax the national bank, and it will eventually destroy it. In fact, in his own words, he says, the power to tax is the power to destroy. And so he cannot allow the states to have that power over the federal government or the federal bank, lest it would actually be destroyed and then rendered useless. So what Marshall does here is he validates implied powers, and he says that states cannot tax the federal government. Now, what that means in reality is that, yes, McCulloch wins. He does not have to pay the government. But it's not just McCulloch that wins. It's the federal government that wins, because they have now gotten validation from the judicial branch to vastly expand the original powers they were supposed to have. I mean, this is way beyond the original scope and intent the Constitution had, and its empowerment of the national government. So this is Hamilton's legacy carried out by Marshall and this Federalist Court that he has in place. So that's it. That's really the McCulloch, Maryland, this justification of implied powers and whether or not you can tax a bank. Please go back and review this if you're struggling or if you missed a piece. That's the point of the video, is that you can go back and review certain sections. It'll always be here, and very good. I hope you feel good about that, and then you'll be ready to discuss it more in class.